If you've been named as an executor in a will, you might be wondering if you must accept the role. Hi, I'm Rani Gander, partner at Turnbull Hill Lawyers. If you have been appointed as an executor and you don't want to take on the responsibility, you can renounce probate. But timing is everything. You need to renounce as soon as possible and before you start dealing with the estate. If you've already taken steps like applying for probate or starting to administer the estate, you may no longer have the option to step down. So, how do you renounce? It's a straightforward process. You need to sign a renunciation of probate form, which a solicitor can prepare for you. This form is then filed in court, usually alongside the probate application. By signing, you are formally stating you don't want to act as an executor and you haven't intermeddled, which is where you have started to take on the role. Now, you might be wondering what happens next. If there's another executor named in the will, they can step up and take on the role. If there isn't, the major beneficiary of the estate may be able to apply for administration instead. But what if you've already been granted probate? At this point, renunciation isn't an option anymore. The only way to be removed is through a court order. That's why it's so important to decide early on if you're willing to take on the role. Being an executor comes with a lot of responsibilities, but you don't have to do it if you don't want to. If you're unsure about your next steps, our Wills and Estates team is here to help. Get in touch with us today. We're happy to guide you through the process.